Now, let's take social conservatives first. Now, of course, from its beginning, the modern social conservative movement has defined itself in significant part as an effort to reverse objectionable Supreme Court decisions, right? Decisions like Roe versus Wade have been a key target of the modern social conservative movement, and over time this movement has developed an increasingly sophisticated litigation network to pursue this effort. This network of social conservative lawyers, both inside and outside the administration, has indeed won several notable cases during the Roberts era. They successfully defended the president's faith-based initiative program against a constitutional challenge alleging that it violated the separation of church and state. They helped defend the Solomon Amendment, a federal law which preceded the Bush administration but was strongly supported by it, which requires colleges and universities to offer equal access to military recruiters, the same access that they give to other employers, a policy that some colleges object to because the military's exclusion of gays and lesbians is inconsistent with the college's own non-discrimination policies. But Congress enacted a law, Bush vigorously enforced it, and the Roberts Court upheld the law, right? So working together, those three institutions have forced colleges nationwide to comply. Social conservatives also also were happy when the Roberts Court rejected a constitutional challenge to a federal child pornography law that was signed by President Bush in 2003, and also when the court rejected a constitutional challenge to the partial birth abortion bill that was signed by President Bush in 2003. Right, the list could go on. Right, there's a number of victories on this court for social conservatives. Two others that I would mention are the court's approach to race-conscious affirmative action policies. Right, where in a pair of 2007 decisions, the court ruled that public school districts cannot adopt race-conscious school assignment plans, and perhaps the biggest victory for social conservatives on the Roberts Court was District of Columbia versus Heller, the Second Amendment decision from just this year, from last summer, striking down the handgun ban in Washington, D.C. on Second Amendment grounds. Now, most of these decisions represent clear examples in which the Bush appointments produced an immediate change in the law. Not all of those ones I just mentioned, but most of them represent clear examples in which the Bush appointees produced an immediate change in the law. In other words, the replacement of Rehnquist and O'Connor with Roberts and Alito produced an immediate shift in the law. Now, Rehnquist was already pretty conservative. O'Connor, so his replacement with Roberts doesn't produce too many shifts. O'Connor was famous as the court's swing justice. Her replacement with Alito produces a number of immediate shifts. Consider the abortion and school desegregation cases, each of which was decided by a 5-4 vote. In each case, Alito voted differently than Sandra Day O'Connor would have. We know this for certain because each decision departed pretty dramatically from a recently decided precedent that was closely associated with Justice O'Connor. And each decision was announced in a majority opinion that marked the culmination of a sizable conservative shift from where the law stood, say, 20 years ago. So clearly some victories for the social conservative movement, conservative litigators in the culture wars, if you will. Even so, I would argue that the revolution that those supporters of President Bush, the judicial revolution that they've been seeking, has not yet come. For one thing, they've lost some cases as well. There's a few examples here. The most notable one was the Roberts Court's definitive rejection of Attorney General Ashcroft's effort to prevent the enforcement of Oregon's Death with Dignity Act. Oregon at the time was the only state that had a law allowing physician-assisted suicide. Washington has now legalized it as well. Attorney General Ashcroft launched a vigorous effort to prevent Oregon from enforcing that law. The Supreme Court turned that effort back. So there's been some defeats as well. Even more importantly, the victories that social conservatives have won on the court have in important ways been incremental rather than sweeping. In the partial birth abortion decision, Kennedy's opinion for the court clearly shifted the law to the right, but he went out of his way to characterize the shift as a small step with limited practical effect. In the school desegregation case, Chief Justice Roberts tried to implement a more dramatic shift toward the colorblind constitution that conservatives have long called for, but Kennedy refused to join him. Kennedy wrote a separate and narrower opinion that deprived Chief Justice Roberts of a majority. The most far-reaching decision, as I've mentioned, for social conservatives was the gun control case, D.C. versus Heller. That decision reversed a 70-year-old precedent from the Supreme Court and unsettled a legal understanding that in many ways dated back 200 years. It did so to adopt a reading of the Second Amendment that has been a key theme in the contemporary culture wars. Even here, though, it's too soon to say how far this change will go. Scalia wrote the court's opinion in that case, and Scalia took pains to indicate that while the District of Columbia's total ban on handgun possession went too far, he went out of his way to indicate that most other state and local gun control laws, which are narrower in scope, are probably constitutional. In sum, social conservatives have certainly had some success before the Roberts Court, but given their transformative goals, there remains a good deal of dissatisfaction regarding the limited progress to date. Social conservatives have in general been very happy with Roberts and Alito, but dissatisfied with the degree to which Roberts and Alito have managed to control the court. In other words, they remain extremely dissatisfied with Anthony Kennedy, who continues to have the court's deciding vote. Economic conservatives. Now, there's a long line of argument dating back to the Reagan years suggesting that Republican elites have exploited the votes of working-class social conservatives to win office, but have then used their power almost exclusively to enact a conservative economic agenda. And along these lines, some early analyses of the Roberts Court, including an influential article by Jeffrey Rosen, suggested that its key accomplishments were legal victories for the Chamber of Commerce. Right? These cases tend to get somewhat less attention than the polarizing culture war disputes like abortion, gay rights, and the like, but their practical impact is no less significant. I don't have time to say a lot about these cases, which again tend to be somewhat less well known. The best known of these cases is probably Lilly Ledbetter's case. Barack Obama mentioned it in the third presidential debate with John McCain in response to a question about the Supreme Court and abortion. Obama pivoted. He said a word or two about abortion, and then he pivoted and he said, and it was a good answer, I thought, he said, you know, the court is important on other issues as well. Let me give you an example. Case of Lilly Ledbetter. Lilly Ledbetter filed an equal pay suit against her employer because upon her retirement, she discovered, because somebody sent her an anonymous note, she discovered that male employees in her same position had long been paid more than she had, and so she went to court alleging violation of federal civil rights statutes guaranteeing equal pay based on gender. She made her way to the Supreme Court where she lost. Alito wrote the court's opinion in a 5-4 decision dismissing her case because it had not been filed, her complaint had not been lodged within 180 days of the original discriminatory salary determination, i.e. the first time her employer paid her less on the grounds of gender, she had 6 months to complain. Well, as Justice Ginsburg pointed out in dissent, salaries in virtually every private workplace in the country are confidential, and it is quite often the case that female employees are unaware that their male colleagues are being paid more than they are. Nonetheless, she was out of luck, according to Justice Alito and the 5 conservative justices. That's probably the best known example. There are a bunch of others. There are, the Roberts Court has imposed strict requirements on when investors can file shareholder suits alleging Enron-type accounting and securities fraud. The court has closed off a number of product liability suits, suits seeking compensation for harm caused by medical devices, cigarettes, pharmaceuticals, and the like. In particular, the court has on a couple of occasions held that state tort claims, state lawsuits seeking compensation for such harms are preempted by the less restrictive regulatory regime at the federal level.